Can I file for a patent? This is one of the most common questions that we receive, is whether or not a client has a patentable invention and if they should file for it. Hi, I'm Jason Rosenblum. I'm an intellectual property attorney. We protect our clients' products, their brands, and their businesses from getting ripped off. So the actual right to file for a patent comes from the Constitution. This is a screenshot from the U.S. Patent and Trademark Office, and it's Article 1, Section 8, that Congress shall have the power to promote the progress of science and useful arts by securing for a limited time to authors and inventors the exclusive right to their respective writings and discoveries. So that actually protects patents and copyrights, but we're just talking about patents in this case. So what makes something patentable? So the considerations are the patentable subject matter, it's novel, and it's non-obviousness. Patentable subject matter is going to say useful, novel, and non-obvious, but it just rolls better with patentable subject matter. And that's probably one of the biggest issues these days with everything being software-based. So patentable subject matter, what is it? Patents may be granted for processes, machines, manufacturers, compositions of matter, or any new and useful improvement of those. Many times we have clients that come to us that talk about a product that already exists, but they have an improvement on it. And that can be patentable. So that's something to know. But what's not patentable? So as I said, this is one of the big stepping stones, is the patentable subject matter. It used to not be as much of an issue earlier in my career, but lately, because so much is based on software, it really is. So it used to the real way that it used to affect us was with laws of nature. So patents are not granted for laws of nature or product of nature. That's things like gravity, speed of light, discoveries of naturally occurring substances, like a new mineral or a plant. That being said, there is a way to protect plants. There are plant patents for asexually reproduced plants. I do not handle those, so I don't know much more than that from remembering when I took the patent bar that that's the case. The other main area where we see more of the issues today is in abstract ideas. And what is an abstract idea? Things like mathematical formulas, algorithms, or general business methods. This is where a lot of what's going on with software, we have to figure out, is this just an abstract idea? Or are we actually rising to the level that there's something more there, something that's creating a patentable invention? The next thing we need to overcome is novelty. Basically, your invention needs to be novel. And what that means is that nobody else has ever done this before. They've never written about it. It's never been disclosed. It's new. It's novel. No one else has done it. If the exact invention has been described in prior art, which is basically everything that exists previously, then it is not novel and cannot be patented. This is something that we can run a search for. And this is what makes it so hard sometimes when clients come to us, is they've never seen it before, they've searched, but does not necessarily clear it for a patent. So we conduct a patent search. We have special software that we use that lets us dive a lot deeper than most people can just do through Google or other web searches that are out there. And it can really help us figure out what is patentable and what is not in a client's invention. And then non-obviousness kind of takes the novelty a step further. And what you're allowed to do in obviousness is say, it would have been obvious from invention X and invention Y, or disclosure X and disclosure Y, to come up with your new invention. And this is where a lot of back and forth happens with the Patent and Trademark Office. As you see, even if the invention is novel, it must also be non-obvious. That means that the invention cannot be an obvious combination or extension of an existing prior art to a person having ordinary skill in the art, known as the person having ordinary skill in the art. This is a more subject criterion and often a point of contention in patent disputes, which is where I'm saying that this is where a lot of the back and forth goes, where we're trying to prove that no, this person would not have been obviousness. And you look at things like teaching away, from the prior art. If things in the prior art said this would never work this way, but you figured out how to make it work that way, that shows that it wouldn't have been obvious. So I hope this was helpful. Jason Rosenblum here. We help our clients figure out if their inventions are patentable, help walk them through the process. You can always reach out to us. Phone number is 888-666-0062 or come to jhrlegal.com. And if you like these videos, please subscribe below. Thanks.